rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for argument in the matter of NORMANDIN versus ENCANTO Adventures, LLC, our civil number 17-0373. Each side will have 20 minutes within which to make their argument here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs, we've been through the record, we've conferenced the case, so we're familiar with the facts, the underlying proceedings, and the issues that have been raised here today. So please keep that in mind as you make your arguments here today. We are recording the proceedings, both by audio and video. The video recording will be available on YouTube in a matter of days. But because we're recording these proceedings, we would appreciate when you approach the podium to start your argument that you identify yourself and your client for us. All right, with that, appellant may proceed.
May it please the court, my name is David Apney. I'm representing the plaintiff appellant. I'm here today with Matthew McClellan. I'd like to reserve a whole bunch of time for rebuttal, 5 minutes or so, maybe more, I don't know. The case presents a little bit of a moving target. When the answering brief came down, there were a bunch of arguments that were raised that hadn't been raised before. I mentioned those in the reply brief and would ask the court to take a look at that as it considers the case. The basic problem is that ENCANTO Adventures wants to be regarded as what it calls a landowner along with the city. But there is no really landowner category as such.
Why aren't they an agent of the city in this setting?
Good gosh, I don't think that argument came up before. I don't think they'd be an agent of the city. They have an agreement with the city that there would be a certain area that they would operate as this little park within a park, and then the rest of the park, including the place where the pinata activity took place, is city land. It's not anything that they lease or control.
But don't they have certain obligations imposed on them as a result of the agreement?
There are. But that's for the land that is separately identified, the separate part where the pinata activity did not take place. Over and over in the lower court, they said that the place where the pinata activity took place was city land. It wasn't their land at all in any way, shape, or form. Now, interestingly enough, they take the time, they say, to maintain it, inspect it, and make sure it's nice for...
Well, I'm looking at the agreement, and it says, except as otherwise provided in Section 16, concessionaire shall maintain the concession premises, which would include the... Doesn't that include the pinata area?
No, Your Honor, it does not. We believe that the record shows that it does not. We cited that in the opening brief and in the reply brief, that the area where the pinata activity took place is a separate part. It is strictly city land. It is not part of this concession land. If there is a dispute on that, it's a factual dispute then, because the way the evidence comes out and the record comes out, in our viewpoint, is that it is definitely separate. And they insist over and over again that the pinata area is indeed on city land owned by the city, not part of their particular area.
But wasn't there evidence in the record that would indicate that, in fact, ENCANTO or the predecessor had maintained this particular area for 25 plus years?
Well, I don't know how long it was, but ENCANTO Adventures did maintain this area. We have no problem with saying that, and we said that very clearly in the opening brief and throughout the proceedings. Sure, they maintained it. They say they inspected it. They said they kept it nice and clean and safe area. But they did that out of their own self-interest. It wasn't their land. It was the place that they would go. There was a hook there off of a nice tree, and that's where they would go as part of the birthday package to have the pinata activity. And you need to have a good, reliable place for the pinata. It's actually a fairly intricate activity at a Mexican birthday party. You don't want it too low for too long. You don't want it too high for too long. It takes a lot of skill to do it. But they did it as part of the overall birthday package. Index of record number 35, page 5, paragraphs 7 and 8 talk about that it was indeed part of the birthday package from Marcy Normandin's perspective. This was part of what she was paying $287 for.
Wait a minute, I'm looking at the birthday package and it says no piñatas. Was it not?
Oh, they don't provide a piñata. They don't provide the piñata bat. But somebody does come out and with the rope and hooks up the piñata and then raises and lowers the piñata as part of the piñata activity.
And did your client admit that she recognized that if she did not do a piñata activity, it didn't change the fee at all?
Oh, sure. But there's lots of things that they provide as part of their package, and any one of those you could just not take advantage of, and it doesn't change the price at all. The fact that there's no deduction because you don't do something that you paid for doesn't matter. You're just not taking full advantage of the money, what you paid for.
And while I would agree with you up until the point that piñata activity is not included in the package, a piñata is not included in the package. You can bring your own piñata and they'll put it up for you, or you cannot. If Pete the Parrot doesn't show up because you've elected not to have Pete the Parrot show up, you're not going to get a refund of Pete the Parrot. You might be able to negotiate it, but that's definitely part of the package. This is definitely accepted from the package. Piñatas are not included.
Absolutely not. I guess I should say absolutely right. The piñata is not part of this. You get your own piñata. Piñata bat is not part of this. You'll get your own piñata bat. But somebody from that company to go and to hook up the piñata, to raise it and lower it, to escort you to the piñata area, actually, that's part of what you pay for. So,
it also says breaking of the piñata is done at your own risk.
Oh, sure. Who wouldn't?
I'm just saying, it seems to me that you're paying for a package that does not include a piñata activity.
No, it includes the piñata activity in the sense of somebody to hook up the piñata, have the rope there to raise it and lower it, to escort you there to the piñata activity area. That's part of the whole thing. The piñata, no, you get your own piñata. The piñata bat, no, you get your own piñata bat. But as far as the piñata activity itself, that was part of the overall thing. They don't just go out there. I mean, the way the answering brief says, well, we just did it out of the goodness of our hearts, just purely gratuitous. But why then are they maintaining that area? Why are they inspecting that area? Why do they have somebody who goes out there, escorts you out there, hooks up the piñata, raises it and lowers it? It's part of the package. It's part of the deal. To return to the statute that is causing so much trouble here, Encanto Adventures is trying to shoehorn itself into that statute by any means necessary. The landowner thing is the argument. And they take the park, the city, and themselves, and they say in the beginning of the answering brief and over again, well, we are the landowners, like some sort of rock band. But they're not. The statute is very clear. It lists specifically who was covered. You've got to be a public owner, and they're not. You've got to be a private owner, and they're not. You've got to be an easement holder, and they're not. You've got to be a lessee, and as we discussed from our point of view of the evidence, they're not a lessee of the piñata area at all. It's city land exclusively.
Well, the agreement specifically provides that they're not a lessee.
Thank you, Your Honor.
But aren't they a manager of this area? And aren't they in control
I just about made
of
it
the
there.
duties of that area?
No,
I mean,
Your Honor.
If they're required and have been doing it for 20 plus years, the mowing, the maintenance, at their own expense, aren't they the managers? At a minimum, aren't they the managers?
No, they're not in the usual sense of a manager. A manager is somebody who can say, okay, get out of here. This is land that I'm managing.
Well, that might be one function of a manager, but it doesn't necessarily mean it's all functions of a manager, does it?
No, but that is one of the hallmarks of a manager. I have the right to manage this property. I am the one in charge of it. I can tell you when to come on. I can tell you when to leave. It's like the definition of occupant that's come up in a few of these cases. A right to control what happens is a hallmark of a manager or an occupant.
Well, what you
under the
described
statute.
sounds more like it would be a leaseholder. A manager seems to me to be somebody who is responsible for certain actions as it relates to the piece of property, like mowing it, watering it, cleaning it up, I mean, those are the duties and functions of someone who's taking control of or taking ownership, not ownership in the legal sense, but the ability for that area to be used.
I disagree, Your Honor. All they're doing is maintaining an area, gratuitously maintaining an area as far as the city's concerned. Apparently, the city's not paying them to do it. But they're doing it for their own benefit. They're simply making this piñata area nice because it is part of the piñata package.
So, Mr. Abney, if in this particular setting, Ms. Normandin and or some of her guests came to the event and they were using illegal drugs or otherwise behaving in an illegal fashion, that your position is that ENCANTO could not eject them from those premises?
It could eject them from its own little area, certainly. I believe that would be fair to say. But as far if they're in the public park and they're doing bad things, ENCANTO Adventures needs to call up somebody and say, get out of there. I suppose they could use self-help, but
Even in an area of the park that you just told us, ENCANTO exercised all degrees of control by escorting people in and out and providing services to hook up, raise, and lower the piñata.
I think you're adding, when you say control, you're adding more than is there. What they're doing is they're escorting people there, they're hooking up the piñata, raising and lowering it. If somebody else came in and said, get out of here, we want to do this, they admit they can't do anything about it. They don't control that area in that sense. They can't schedule things in there as far as exclusivity. It turns out that this seems to be an area that they use as a matter of custom, and they get away with using it, as part of their business on a regular basis. But no, they don't control the area. They're not a manager in that sense. They're not an occupant in the sense of the cases. They simply don't fit that long litany of individuals and entities that are listed in the very opening part of the statute. They're just not there. In the answering brief, they tried to fit in a whole bunch of them by saying that they're an owner, a lessee, a manager. They abandoned the occupant argument, which they seem to be making down below. Now they say we're not an occupant. As they said on page 28, it need not establish its status as an occupant or other holder of the premises. Well, if they're not a holder of the premises, what are they? In relation to the statute, they're nothing. The basic complaint here is that they were negligent in what they were doing. They escorted the party over to the piñata area. They claimed they maintained the piñata area, that they inspected it, they wanted it to be safe, and yet it wasn't safe. And as when Marcy came over with her daughter in her arms, she fell into this depression, divot or whatever it was, and broke her ankle. So they were negligent in the activity that they were conducting. They just don't fit within the premises within the definition of anything under the statute. Nor is Marcy what would be considered a recreational user. Assume that they did fit within the statute, $287 for this kind of an activity, this birthday activity, is a lot of money. No matter how you slice and dice it, that's a lot. That's not.
If I went over to ENCANTO Park today, could I go to the piñata area without paying any money?
You bet you could.
All right.
Absolutely.
And, if I wanted to have a piñata activity in the piñata area, I love saying that, by the way. If I could have an activity in the piñata area, could I do that without paying any money?
Sure.
And if I want to go ride the rides, I have to pay money.
If you're in the ENCANTO Adventures area where they have these different things, you would be paying some money.
Right. So, and when we talk about what it was she purchased for $280 some odd dollars, she purchased tickets to ride the rides, a bunch of other things.
T-shirt.
Yeah. Pete's parrot comes up to visit, all sorts of things.
Sounds marvelous.
She gets no discount if she doesn't do a piñata.
She gets no discount. She doesn't do any of the many things.
So how is that fee related in any way to her travel through or to the piñata area?
Are you devoting the question to the city or to ENCANTO Adventures or to both?
Both.
Okay.
Either. I don't care. I just don't see how it is money related to the entry or travel over that piñata area, since it's not restricted. It's a park. Anybody can go, anybody can do a piñata activity.
Well, the answer to that would just simply requires reading the statute a little bit longer. When you go past the first part of that definitional part, I think it's subpart C5, talking about recreational user. Yeah, it talks about the travel across or enter. And then if you continue on with that sentence, or engage in other outdoor recreational pursuits. She was engaging in another outdoor recreational pursuit. It's not just to enter and travel across. You have to read to the end of that sentence, and it talks about other outdoor recreational pursuits. And that's what she was doing. But then again,
I can go do that right now and not pay anybody a nickel, right?
exactly. But if you get engaged with Encanto Adventures as part of the birthday package, and you're escorted over there by them and to an area that they say they maintain and inspect, then they have assumed a duty to you as part of this overall thing to warn you, at least. Watch out, there's a hole there, and if you put your ankle in the hole and you're not looking, you're going to break your ankle.
But she's engaged in an outdoor recreational pursuit in an area that has no entry fee.
Correct. So
and no charge.
as far as the city's concerned, and that's, and I have to say, it hasn't come up, but the city, trying to hold the city in this case is very, very, very hard. Because if there is a fee that's being charged by the city, it's indirect. It's coming through Encanto Adventures, and there just wasn't enough discovery done to figure out exactly, how all that would work. But for Encanto Adventures, remember, this is a negligence case. If they are negligently conducting that activity, and they did, then they are liable if you get injured. If I may preserve my time.
All right. Thank you, Mr. Abney.
Thank you, Your Honor.
Good morning. I'm Joseph Brownlee, and I represent the Appalese, the City of Phoenix, and Enchanted Island Amusement Park. If the court will allow me, I'd like to first address the contractual issues between the city and Enchanted Island Amusement Park, then the factual issues under the statute, and then the constitutional issues that I'm sure are going to come in the rebuttal. As the court correctly noted, the agreement, the concession agreement, which is document 38, does have some very specific language that the appellant did not address. Under the recitals, it says that this document governs the picnic island.
What are you referring to? I just want to follow. I have it in front of me. I just want to follow along.
Recitals, page 1.
Thank you.
It refers to, the agreement refers to the picnic island. And it says the concessionaire desires to secure exclusive rights in the concession premises. It goes on in number 1 to say, grant description of the premises. Grantor grants to the concessionaire the right to use the area known as the picnic area, and the right to use all other portions of the concession premises. If I may,
Is the concession premise, does the piñata area include, is it encompassed within the concession premises?
with the court's permission, I would like to have the bailiff hand 2 exhibits, which are
Well, I think we might
their
have.
Appendix B. There are 2 exhibits there. One says Exhibit 3, one says Exhibit 4. Exhibit 4 is a blow-up of 3. Here's why I think these 2 exhibits are important. We've got Encanto. It becomes and we've got Encanto City Park. and we've got Enchanted Island Amusement Park. To try to make this understandable, I'm going to refer to Encanto City Park and Enchanted Island Amusement Park. You can see how they are divided. The right side is Enchanted Island Amusement Park. The left side is Encanto City Park. And if you go down below, it is the development plan for Picnic Island. This is a whole island surrounded by water. So when the agreement refers to Picnic Island, it refers to the entire premises. And back to the agreement, page 10, paragraph 24, maintenance, care, and inspection of the premises. A, concessionaire shall maintain the concession premises in good order and repair of its own expense during the entire term of this agreement.
Mr. Brownlee, I'm sorry to interrupt, but looking at the diagram and looking at the label, it says Picnic Island / Kittyland.
That's true.
And on the left side of the diagram, it says open space picnicking,
Yes,
and the right side is where these rides are.
correct.
Can one interpret this drawing to refer to limit Picnic Island to the open space picnicking area?
No. Picnic Island under the agreement is the entire island, which is listed in recitals as Exhibit A. This is also attached to the agreement. So that's where it becomes very important to identify that Picnic Island is the entire thing. Now, interesting, if we...
And I
Yes,
just
sir.
want to be clear, and I'm going to go back to the question I asked you. When the agreement says concession premises, is it referring to the entire Picnic Island, or is it referring to something else?
referring to the entire Picnic Island. And Mr. Lyon, the owner of Enchanted Island Amusement Park, testified, which is an exhibit in the record, that he maintained the Enchanted City Park green space over here. He maintained that, which includes the small 30 by 35 area known as the Piñata area.
So the way I understood his testimony is he maintains all of this, and it's because he believes it's required under the agreement that he maintained the concession premises.
That is correct, and that has not been controverted at all. He maintains it. He goes out there. Now, you'll notice in Exhibit 3, parking on the other side of the canal, and then enter. This is how you enter. So when the appellant entered, she passed the Piñata area. Didn't pay $1, didn't pay a cent. She passed the Piñata area and then went into Enchanted Island. If she'd gone to the Piñata area before her birthday party, no fee. If she'd gone to the Piñata area after her birthday party or any other day of the year, no fee. And she testified upside and downside that she didn't pay a fee to break her own piñata that she bought sometime earlier in the piñata area. So, as far as the statute is concerned, again, the yellow part, she traveled across city land and, forget the other thing, entered
She engaged
city.
in recreational activity on city land
Correct.
in the Piñata area.
Correct. And the second agreement is just shows a bigger expanse of it, but she clearly passed the Piñata area. She traveled over it. She entered to it without fee, as she could do any time of the year. Fact that it happened in the middle of her birthday party is irrelevant for these proceedings. It had nothing to do with it. She testified over and over and over again about that. As I can see, now I'm going to go to the facts of the statute. The only thing that the appellant has to keep the city in this case and not allow the statute is the $287 birthday fee. Well, number one, it's not $287.
Package.
That's right. It's $265, as we said in document 80, page 12. That has never been controverted. It's $265 plus taxes, which makes it $287. Why is that important? Well, that's important because this court in Allen versus Town of Prescott Valley, I discovered a day or so ago, held that $270 is a nominal fee.
Well, it was nominal because you used the softball diamond several times, and so they prorated it to each time that.
That's correct.
Okay.
But it flatly says $270 is a nominal fee for the entire team. Remember that? So we don't say that she paid anything for the piñata area. But again, because you're supposed to weigh the facts most in the favor of the appellant, even if the $265 birthday party fee somehow included, somehow, some way, the piñata under Allen versus Town of Prescott Valley, $265 is less than $270. And we'd ask the court, as a matter of law, to hold on the record right now that...
not asking us to say that the nominal is now $270.
That's what you held in Allen versus Prescott Valley.
Because we didn't just take the fee, as in a certain amount. We looked at what the fee encompassed and prorated it, right?
Correct.
So in this case, I guess we could look at the fee and say, well, you paid for how many?
30 up to 30.
There so many guests, and it included so many tickets, and then we could start proportion it down to what it was per item, and then try to figure out if there was any type of charge for piñata activity. But we can't just say $270 isn't nominal. It's certainly not nominal to me.
Well, if I read the court's opinion wrong, we conclude that the $270 the town charged Allen's team likewise was a nominal fee.
Well, under the circumstances of that case.
Right. So I'd ask you to apply the same circumstances, and this is a nominal fee, if that even is of issue. I'd now like to turn briefly to Enchanted Island. The concessionaire agreement is really looks a lot, smells a lot, walks a lot like a lease. But, so I submit to you that the requirements on Enchanted Island Amusement Park to the city are very similar to those.
Except
of a
the
lease.
agreement specifically says it's not a lease.
That's true. That's true. But it also, the statute also talks about manager. And under the testimony of Mr. Lyon, the owner of Enchanted Island, and paragraph 24 that I just referenced, clearly Enchanted Island is a manager. Clearly they fit under the statute, which then allows us to go further to the other things. There should be no question, there are no abrogation issues regarding the city. Dickey versus City of Flagstaff is a seminal case on that. And the cases of Armenta, Smizer, Andresato, Herman, Ward, and Prince all hold that a municipality, whether it's a city, a state, or a county, the anti-abrogation clause does not apply to them. So in this case, the city should easily qualify for the recreational use statute 33-1551. By pointing out that we said landowner, we're not really saying Enchanted Island owns the land, because there's a limitation on pages and characters. We use that to all encompass the 6 things. But as did the trial court. But it's clearly that Enchanted Island is a manager of the piñata premises as well, without fee. I want to talk about the legislative history of the recreational use statute. There are many cases. They're all about the corporations. I'm sorry. They're all about governments. They're not about corporations or individual people. And I know you're well aware of the record, but I would like to point out the Supreme Court's footnote in Bledsoe versus Goodfarb, where a representative, Jim Matliff, testified in support of the recreational use immunity statute. John Olson, Arizona Cattle Growers Association, specifically said, unless people who control private land receive assurances through legislation and that their liability is limited, we're going to have a serious access problem in this state. This court should issue a ruling regarding the duties and protections of private landowners under the statute. I have not found one in the state of Arizona. They're all about governments. This is not just an Arizona statute. As Dickey said, all 50 states have them. The initial legislative history of this statute was for private landowners. It was only later that governments were added. Also, in both the response and the opening brief, we cited the 2007 recreational use compendium, which I'd like for you all to also include as well. That has not been cited yet in any of the subsequent cases. I think it's important because it is a compendium of all 50 states. The constitutional arguments are very important. McKinney versus City of Tucson said it's okay to decide constitutional issues where they're briefed and oral argument has occurred, even if they're non-constitutional grounds. This statute for private landowners, like Enchanted Island, is ripe for an opinion addressing private landowners. In Dickey, the Supreme Court said Arizona's anti-abrogation provision was designed to protect rights of action and existence at the time it was adopted, but not necessarily those later created. There are two cases we cited that govern a statute creating a classification that never occurred in the common law. One was organ transplants, and the other one was governmental immunity, judges, legislatures, and so forth. If there was a strong public interest in protecting landowners, we suggest that you should create a new clarification of individuals and corporations under the statute called the recreational user. I don't know why we're dancing around it. I know we all talk about invitee, lessee, and trespasser, but in this statute, it creates a new classification, recreational user, and it has defenses. The appellant in opening talked about negligence. That is also what the plaintiff has always claimed, but the statute says it doesn't apply if you have willful, malicious type of conduct. So there's a defense that's written right in to the statute, and they have not pled willful, malicious conduct.
Mr. Brownlee,
Yes.
your time is running low, and I really wanted to talk to you about your Rule 68 request for sanctions in addition to fees. Are you aware of any time that Rule 68 sanctions have been applied at the appellate level?
No, I'm not. And if I misspoke, then I will drop it.
I don't know that you misspoke. I'd like to hear your argument.
Well, we had an offer of judgment. The trial court ordered Rule 68 sanctions. And the case still proceeds. We submit that Rule 68 should also cover this type of proceeding. I really would like to get to the Ramirez case if I can. Okay. That was a case of first impression. Justice Palander wrote a very lengthy opinion, said it was new law based on a uniform law, just like this. No right existed at common law, just like this. And if no such right existed, Justice Pelander said, then the anti-abrogation clause is not implicated. We submit that the legislative duty history clearly supports finding a new classification, even though it didn't exist at common law. Ramirez said that the legislature may regulate tort law, constitutionally may regulate tort law, but not abrogate. In the recreational use statute, it regulates, but it does not abrogate, because you still have a right of action if there's gross negligence, malicious conduct, and so forth. We will not interpret law to deny, preempt, or aggregate common law damage actions unless the statute, text, or history shows an explicit legislative intent to reach so severe a result. We have that in this case. Finally, analogies to the Ramirez case, the court said there are sound policy reasons for requiring more than negligence to impose liability on those persons who participate in, and now I add, recreational activity on private land and public land. There is a critical state interest, there is here, to encourage recreational activity, there is here, and protecting recreational activity on public and private land. That's the same as the recreational use statute. To accept plaintiff's contention that anti-abrogation wipes out this statute completely abrogates or automatically makes unavailable this statute to private landowners. And that was the reason for its basis to begin with. So we shouldn't dance around. We should embrace that. I urge you to make, in your opinion, A, new classification recreational user, B, it's never been in common law, and C, there's a compelling state interest to uphold it. And I'm out of time. Oh, equal privileges are not violated because the state has a long, legitimate, and compelling interest in protecting private landowners under recreational use. Thank you very much.
Thank you, counsel. Mr. Abney?
I want to thank my colleague for these beautiful exhibits. And if you look at them, you can see the Pinata area is clearly on the City of Phoenix and Encanto Park side. We addressed the lessee issue on pages 7, 8, and 9 of the reply brief. And if I just want to touch on a few of the things there.
Well, could we go back to the other one? Because for me, I'm more interested. Exhibit 3 that was attached to the original agreement that was entered by Encanto, Encanto's predecessor and the city. And it appears to me, in looking at this, that it was the intent to have this be the concession premises, this island. You disagree with that? And if so, could you cite to me where in the record that interpretation was not used or not encompassed?
I don't think that was the original intent, but in the record, and it is on 7, 8, and 9 of our reply brief, it's very specific about, in this particular case, what happened. There was an argument that they were a lessee, but...
okay, but the agreement says they're not a lessee, so...
But... Okay, well... I'm not trying to be contrary, but I think what happened is they claimed down below they were a lessee of the right-hand side, the Enchanted Island Amusement Park. In the summary judgment motion, they stated that it was a lessee of Enchanted Island Amusement Park, and that's on page 8 of our brief. It's Index of Record 23. And they said that Marcy Normandin went outside Enchanted Island Amusement Park and to the adjacent area in the park where the piñata was attached to the tree, and that she suffered injury in the city-owned piñata area. And then they went on.
City owns the whole thing. I mean, this is not like Encanto owns the amusement park area.
True, but then they went on in their summary judgment motion reply, Encanto of Interest says that Marcy was desperately trying to move the location of her injury from city property back inside Enchanted Island Amusement Park, but Encanto Adventures said it was undisputed, their own word, undisputed, that Marcy's injury did not happen on Enchanted Island Amusement Park's property.
But-
It didn't happen on the property that they said that they were leasing. They said they had leased that right-hand side, that was where the lease argument came in originally. And now they're saying they leased the whole thing.
Okay, I do want, and we'll finish, I'll finish going through the record myself, and I'm sure my colleagues will, but I do have a question to follow up on Judge Campbell's question. Say for a simple argument that we disagree with your position. Do Rule 68 sanctions apply to appellate work?
I can't imagine why they would. I mean,
Why wouldn't they? The rule, in reading the rule, it doesn't seem to exclude them.
well,
You're not disputing there was an offer of judgment,
there was an offer of judgment.
and you're not disputing that you received less than the offer of judgment.
Well, zero is pretty much less.
That's what I was saying. So why, the rule doesn't say otherwise, so do you have any authority or anything that would indicate to the contrary?
Offhand, I don't, but I just, it baffles me. I'm not sure what they're going to say is the Rule 68 money that they want related to the appeal. I don't know, maybe attorney's fees. I don't know what it is exactly, but I've never heard of it happening. I've never heard of anybody ever making an argument like that. If the court would indulge me, I can investigate that and give a supplemental brief in a.
Well, it was raised in the briefs. I was just curious if you had anything additional that
No,
you thought
no,
about.
Your Honor. But if you are going to take a look at the concession agreement, you may want to take a look at the exhibit that was attached to it, which is the original version of the how this all was set up, the Enchanted Island Amusement Park, the City of Encanto Park area, and you see how they match and don't match.
Well, it's the same one minus the sans the color, correct?
Well, it's somewhat different. There was a future restaurant sites on the left-hand side, and a lot of the markings that are on the exhibit 3 and 4 that were provided are not the same. So, if you want to compare those later on after argument. And I have run through my time. If there's no further questions.
Thank you, counsel.
Thank you, Your Honor.
We appreciate the arguments made here this morning. We're going to take this matter under advisement and issue a written decision in due course. And with that, we are adjourned. Good day.